Welcome to the Near Memo, a weekly conversation about search, social, and commerce. What happened, why it matters, and the implications for local. All right, I won't bring that up now. So, so there's just a number of interesting things here. So let's segue into the second related item, which is the European Court of Justice decision in the Google shopping search case upholding the fine, but they also said some interesting things. So this is a case that originated 7 or 8 years ago, I think.
Oh, it might have been longer than that. I think it's like 2012.
Yeah, it's a very old case in which I think Foundum originally, there were a couple of antagonists here, sued Google for antitrust effectively. Or maybe they didn't sue Google, but there were complaints to the European Commission, which regulates competition, ultimately resulting in a essentially €2.5 billion fine for anti-competitive abusive market practices. There was an appeal and then another appeal, and this was the highest court, and Google was appealing the fine. And what did the court say or find, David?
They found Google liable. They basically denied Google's appeal and found them liable for this €2.5 billion fine, which it should be noted is a tiny percentage of Google's annual revenue, but importantly, 1% of annual revenue, and amortized over the 12 years that this case has been going on. It's even less, right? So, but I think importantly, it probably gives the European Commission a little bit stronger leg to stand on as it takes action sort of along the lines of or enabled by the Digital Markets Act to actually regulate Google's behavior, not just in shopping, but importantly in other verticals, right? So I think my reading, which is not direct of the actual legal opinion, but a couple of scholars and lawyers that I follow on LinkedIn who read the opinion highlighted the fact that the court actually sort of separated out, or the court highlighted Google's use of boxes in their search results,
right.
And that the sort of anti-competitive behavior taking place in the boxes is kind of what drew the decision or helped reinforce the decision. And so if you think about the number of boxes that Google is using in other verticals, including local, including hotels, including jobs, right, where this same logic could be applied, I think it gives the European Commission, a strong indication that regulation is not going to be sort of able to be appealed to the High Court, and the fines that the DMA proposes are much, much higher than 2.5 billion euros. They're 10%, or I think even 20% of global revenues. If
there's, I think, a repeat. I think if there's
found to be repeat violations. So I think that the 2.5 billion is nothing, but the implications of this opinion sort of giving the European Commission a little more confidence to proceed with regulation, I think, is the real important takeaway from the opinion.
Like in the United States, because of the decision against Google, Yelp filed their own individual case against Google. Is there something similar that could happen in Europe where businesses that have been harmed by this behavior could bring suit and in pursuit of reimbursement of their own losses?
That I do not know. And I would say anybody who's listening who's really interested in this case and its implications, the main guy that I've been following is a guy named Thomas Hüppner, who's a lawyer. I presume his law firm is German. I'm not sure, but he's based in Brussels. And he was one of the lead attorneys that sort of got this case going. And so I think he's probably the best source to answer that question, Mike.
If you would share, we'll share his LinkedIn link in the show notes.
Thanks for joining David, Mike, and Greg. To stay on top of the latest developments in local, subscribe to our newsletter at nearmedia.co. We'll see you next week.